So I need your assistance. Thank you. Thank you, Ms. Mkabayi.
Thank you, my lord. My lord, I am Ms. Mkabayi from Mkabayi Attorneys, and I confirm that I appear on behalf of Mr. Van Rijn in this matter. I further confirm that these are judicial instructions.
Oh my goodness, I have a confession, okay? The second she introduced herself again for the umpteenth time in Judge Nathan's courtroom, I almost was like, okay, here we go again with the drama. I had low expectations of Mkabayi's heads of argument. That's my confession, okay? That's my confession, that's my opinion, and it's based on basically what's been going on in court throughout. It feels like the last day of school. And suddenly, hello, Mkabayi shows up to the party. And it's like, where has this defense advocate been this whole time? Listen, she impressed me. I was thoroughly impressed. And I also found myself, I have about 5 pages of notes from Mkabayi's, speech. Or should I say heads of arguments. And I want to say I am disappointed. I want to go on record and say I'm disappointed she did not. Or should I say that she and her client, or depending on how it happened, okay, or per her client's instructions, they decided to go for Section 35. I'm disappointed. There are so many points that she hammered in her heads of arguments that they could have brought to the court in their defense strategy. Unfortunately, they decided to just sit in the court and say, we've got no further questions. We plead Section 35. My client has the right to remain silent. And silent he remained. But Mkabayi really, really brought up some points that have me pausing and saying, yeah, she's got a point. Is it truly a crime that Steffi was trying to sell his microwave? Did the state prove to us what happened to Joshlin? I mean, there is no victim. The state said so themselves. And then Mkabayi says, where is the exploitation? Who is the exploiter? Where did the location of this exploitation happen? And I say, Mkabayi, you're right. We still don't have. There's a ruling that is going to be done on Friday. But we members of the public jury, we still have all these questions. There's so many questions. Mkabayi delivered in her heads of argument. I absolutely love it. It was brilliant, okay? It was absolutely brilliant. Some of the key notes that she mentioned as well is, on the 19th of February, my client was selling a microwave. My client went to visit his friends. When did it become a crime in South Africa to sell a microwave? When did it become a crime to visit your friends? And you know what? She's got a point. The state did not prove, at least to me, beyond reasonable doubt, that this is what they were doing. She, of course, teared down, okay, Renz's testimony. She just shredded it to bits. Of course, as the judge and the state predicted, she called her liar, inconsistencies. That she specifically asked her, do you believe in God? What are the consequences of lying? And I remember that moment when Mkabayi asked that question and the judge did not object. The state did not object. I was like, where is Mkabayi going with that question? But look at her tied so nicely with a bow in her heads of arguments. I didn't see Mkabayi coming this fierce with her heads of argument. I'm just going to be honest. As you notice, I haven't done a review on Butta's head of arguments from his attorney because it was dragging. It was dragging. But Mkabayi, I believe, of the 3 learned colleagues on team defense, Mkabayi pulled through. Mkabayi came for her client and represented, and she said, where is the common purpose? Common purpose of what? I've given you a long intro. I think it's time you listen to Mkabayi yourself. Take heed of what she said. At the end of the video, make sure you watch till the end. Let me know in the comment section down below. Are you still 100% convinced? Let's just put aside the fact that we want justice for Joshlin. I still want that. Has the state done a good job convincing us that all three are guilty of the charges against them? Who is the exploitator and who has Joshlin? I would like to hear from you. I'm counting on my Lord. Listen, I'm counting on my Lord's expertise on this one. Mkabayi brought some good points. It will be interesting to see how my Lord will get through this. We saw as well how my Lord did not disrupt her. You know how with the state it was such a conversation, engaging conversation, not with Mkabayi. She was going. Okay, let me stop here so you guys can hear Mkabayi yourself. Here goes.
My Lord, yesterday, or before I go there, my Lord, when the news about Joshlin's disappearance broke, the whole country came to a standstill. Not only South Africa, my Lord, even the global village. But the unfortunate part in this matter is that the investigation didn't do justice in this matter. Mostly, my Lord, poor investigations, they have a tendency of leading to unlawful arrest resulting to malicious prosecutions. In this matter, the state has a duty, it has an onus to discharge each case beyond reasonable doubt. I have listened to my learned colleague yesterday from early as 8:30, including 1 o'clock. She didn't come closer to prove their case beyond reasonable doubt. There's no evidence before this court that my client, Mr. Van Ryn, did unlawfully and intentionally deprive Joshlin of her freedom of movement. There is no evidence before this court that my client, Mr. Van Ryn, delivered Joshlin to anyone for any amount. My learned colleagues were noticing that they failed to discharge the onus. They are pleading with this court to convict Mr. Van Ryn on speculation. Speculation drawn from the evidence of a 204. My Lord, I would like to pause and look at the person of this 204 before even she was arrested. She testified before this court that she was taken to Langaban. While in Langaban, they were taken to an open space where they were assaulted severely. And while they were assaulted, they were asked about the disappearance of Joshlin. She testified that the people who were assaulting them, it was herself and Ayanda. Ayanda is known in this court as her partner. They were assaulted by people who were covering themselves with paratrap. They were assaulted, they were taken back to Langaban. From Langaban, they were taken to police station. At the police station, her partner was released, but after some time, she was arrested. She was arrested on the 13th of March, 2024. We've got this 204, after being, or during the assault or the torture, she doesn't confess to the people who were torturing her. We've got this 204 who's arrested on the 13th of March. She's appearing in court. She doesn't confess. There's something I know about this offense. I've got information that can help the state. She's quiet. We've got March 2024, April 2024, June, May 2024, June, July, August, September, October. October 21st, 2024. The same person who was tortured 7 months before is saying now, I can confess. That and that alone is saying a lot about this 204. Let's bring her before court. Before she was brought before court, she was taken before Sergeant Ssmith for a statement. Sergeant Ssmith is such a polished police officer. She impressed me when she was administrating an oath to Laurentia Lombard. She told the court that I am fluent in Afrikaans. We spoke in Afrikaans. But I wrote my statement in English, but she understood everything. After I wrote my statement, I read it back to her. I asked her, do you understand? The answer was yes. She took an extra mile further by asking her, do you want to add anything? Do you want me to correct anything in your statement? The answer was no. After that, an oath was administered. She said, even though she was twitching her arms, but she could understand. While I was taking her statement, this is a testimony of Sergeant Sofobe, she made me to believe that what she was telling me is the truth. Now, when confronted under cross-examination, no, I was scared. Scared of what? Sergeant Sofobe is more or less of her age. He's young. I was scared. Maybe I had a relapse of drugs. So that's why I lied. What is surprising me worse, my Lord, is that she knew she was lying, but she continued. Like, that's not even a lie. She fooled an officer. That's the 204 we're having before this court. As if that was not enough. Now, she went to give a confession. She didn't stop. She's responding to the officer was taking her confession as a woman with a gray hair. I suspect she looked older than Sofobe. She was supposed to respect that officer. These people are trained. These are the pride of our country, law enforcement officers. We've got a 204 for the second time who is lying before an officer. In court, her confession was amended by the state. Which value do we attach to that confession? With its lies from the owner, with its amendment by the prosecutor. As if that was not enough. Now she's appearing before Captain Lombard. She doesn't stop lying.
I'm with you.
When 204 statement was brought before this court, it didn't stand the test of cross-examination. There were many lies, contradictions, inconsistencies. Now, if we take the defense when she first appeared before Sergeant Sofobe that she was relapsing from drugs, was she even relapsing from drugs after 7 months on the 21st of October? When she lied. Was she still relapsing when she lied before Captain CS? No. I asked her, do you believe in God? Were you brought up in a godly family? He said, yes. My parents told me about God. I asked her, do you know the consequences of lying? She said, yes. She even said, even in school, my teachers told me about God. They told me about the consequences of lying. But she didn't stop lying. We cross-examined her, 3 of us. She lied to my Leonard colleague for Mr. Apollis. She lied to me. She lied to my Leonard colleague for Miss Kelly Smith. Now, surprisingly, the state is convincing the court. Now that I have failed to prove the elements of kidnapping, trafficking, please, let us convict the 3 on speculation. Wow. Where is that coming from?
You have to give Mkabayi credit. That is a valid point. The state has not proved any of the charges. However, now the state says, my lord, convict on speculation. And who is the speculator? It is Rance. And is Rance a reliable witness? According to the defense, absolutely not. She's been lying the entire time. She lied to 3 police officers. She lied to the court. She lied to my colleague. Basically, the common word is lies, 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 lies. We also heard my lord say that yesterday. But the state argues that she might have lied. But just because she told 1 lie or 2 lies doesn't mean everything she said was a lie. And unfortunately for Mkabayi, some of the things that Rand says, which are not lies, are corroborated or oh my gosh, why am I tying that word? Are corroborated by her own client, aka the microwave story, They're also corroborated by Mr. Apollos. So it is difficult to throw everything out, I believe, for my Lord, Judge Ndim, to throw everything out as lies because some parts are actually true. So it's going to be interesting on Friday to see what my Lord will decide. And Israel's going to be in court on Friday. So he's going to give the judgment on the three, and then he's going to say yes or no to an honorary discharge for Rance. The substance I used, what's going on with my English? The substance user who has a prolonged history of over 16 years of using substances more than once a day, more than 2 times a day, at most sometimes 3 times a day. So it's going to be really interesting on Friday. Wow.
Speculation, we're drawing the inference from the evidence that was led by 204. Which 204? The one who lied uncontrollably. The one who fooled 3 police officers. Now let's go to these speculations. When she was giving evidence, my learned colleague asked her a leading question. Who were present in the discussion? 204 has never mentioned anything about a discussion, but my learned colleague asked her, who were present in the meeting? I knew discussion. I knew that word discussion, where it was going to. I knew it was going to concoct the principle of common peoples. She mentioned 6 people who were present in the meeting. Another surprise, my Lord. In that list of 6 people, she mentioned Joshlin, she mentioned Requeen. A follow-up question, very fast follow-up question was, where was Joshlin? Where was Requeen? Now he's placing them in different places. Requeen was in his bedroom, Joshlin was playing outside. I noticed that discrepancy. I waited for my time for cross-examination. But unfortunately, there was a ruling that I cannot put questions on that piece of evidence. I knew that piece of evidence is going to take us to the principle of common peoples. My Lord, I object strongly. The state is not going to come and say there was a discussion. The state is not going to come and say there was a plan. The state is not going to come and say, yes, discussion, meeting, or plan. The state has to unpack and break down the discussion. In the discussion or meeting or plan, what was my client's role? What were his ideas? What was his input? Who was the chairman of the meeting? Where are the minutes of the meeting? We're not going to allow a state to come and thumbsuck meeting plan without the basis. I will argue that. The meeting, the plan, the discussions are unfounded and they're baseless. And the state cannot cry common peoples without first proving the elements of this of the main charges beyond reasonable doubt. We're not going to have a common purpose. It's a common purpose for what? Common purpose to do what? My client didn't deliver Joshlin. They didn't prove that. They didn't prove the intent. They didn't prove unlawfulness. They cannot. Another issue. My learned colleague argues yesterday that there was an act. Who acted? When? With who? When you traffic, you don't traffic alone. There's the other person. Where was this act? With who? Silent. Their conduct. Whose conduct? My client's conduct that day was his conduct even the other day previously. Did the state know how did my client conduct himself before the 19th? Which conduct are they referring to? My client on the 19th of February was selling the microwave. When did it become a crime in South Africa to sell a microwave? When did it become a crime in South Africa to visit your friend? I will argue that that was a common purpose to sell a microwave. not common purpose to kidnap or to traffic anyone. My learned colleague argued that Joshlin has been delivered, and she has been delivered for the purpose of exploitation for slavery. By who? Where? Who are the exploiters who are exploiting Joshlin? We want to know. In which place? She has to tell this court. She didn't. For 4 hours, 30 minutes, I was listening patiently for the state to prove its case beyond reasonable doubt. No compelling evidence before this court, no strong evidence before this court suggesting that my client committed an offense of trafficking in person, kidnapping, and all, any conspiracy.
Once again, Mkabayi learns her plane and she learns it really, really well. Now let's assume we had a jury system and you were part of the jury. After what Mkabayi has said, which is literally, the state says that Joshlin has been delivered and been delivered for exploitation. Mkabayi says, who are the exploiters? Who are these people who are exploiting Joshlin? Where did this delivery occur? We want to know. And myself, as a member of the jury, I stand with Mkabayi on this one. Yes, I do. I still want to know. I've been asking video after video after video, but where's Joshlin? The state themselves said there is no victim. They have no victim. There's no victim's voice. But the state is boldly saying this was an exploitation. Joshlin is being exploited. And let me tell you, I do not want to imagine what type of exploitation she's talking about. And maybe, it's being in La La Land that we wish for the best for her. But there's some very, very evil people in the world. Is it sexual exploitation? Is it labor exploitation? Is it child exploitation? Which exploitation is it, state? And knowing what that exploitation is, that will help the court throw the book at these 3 accused. But from where I stand, did the state prove beyond reasonable doubt that Steffi was part of the exploitation plot? Or is he a victim of circumstances of being at the wrong place at the wrong time? Let me know your thoughts in the comment section down below. I definitely want to know where you stand with regards to what Mkabayi said. Put aside that, we all love and want Joshlin back in safe hands. But has the state proved what exactly happened to Joshlin? Has the state proved this?
I will refer this court to, those cases the court said I cannot, there's no need for me to refer to them. Now the point I wanted to make, my lord, is the point I wanted to make, this onus has not shifted. This onus is still upon the state. My client is not guilty to prove his innocence. He has no duty to do that. The duty is upon the state. The duty that they've run away from. They know why. Now coming to my client, on the 4th of March 2024. Where was my client on the 4th of March 2024? On the 4th of March 2024, my client was at Vredenburg Saldanha hiking spot. He was with his cousin's boyfriend. He's hiking from Vredenburg to Saldanha. It was in the afternoon. While he's hiking, he was taken by the police. They never told him, they never introduced themselves to them. We are the police officers. We are looking for you. We are looking for you because you are a suspect in this case. Arbitrarily, they infringed his right to human dignity. He has a right, constitutional right to be treated with dignity, a right to be treated with respect. That right applies to anyone. You are educated, you are not educated, you are rich, you are poor. It applies to every individual person. I will argue that Section 10 of our Constitution, that gives my client rights to be treated with human dignity, was infringed by the police who took him at the hiking spot. I will refer this court to the case of Mahlangu.
Which one? Is it one of the cases that you sent me?
My lord?
Is it one of the cases that you sent us?
Yes, my lord.
Mshlangu.
Is J.E. Mahlangu? IT Mailela?
It's not one of the cases that we've uploaded, but if you give me the name of the case, I'll find it quickly.
Can I show because just the front page? Maybe we'll quickly get it.
It's not one of the cases, but I'll quickly find it. Yes, it's the Constitutional Court case of Mahlangu versus the Minister of Police.
Yes, my lord.
2021, ZACC, page 10. Yeah, what about it?
My lord, I would refer this court to paragraph 27 of the case.
Oh, first tell me what was this case about in the Constitutional Court?
This case was about it covers two things. It was about the confession. I'm not going to concentrate on that. And it was about the infringement of Mr. Mahlangu's rights, my lord.
This was a case that dealt with the damages.
Yes, my lord, at the end, yes.
Following from
Yes, my lord.
an unlawful arrest and detention.
Yes, my lord.
You want to take me to paragraph?
Paragraph 27, my lord. The unlawful deprivation of liberty with its accompanying infringement of the right to human dignity has always been regarded as a particularly grave wrong and a serious inroad into the freedom and rights of a person. There's a reference in that paragraph, my lord, to the case of Tandanani. I don't have that case of Tandanani.
Well, it's Tandani versus Minister of Law and Order, 1991. One is a 702 Eastern Cape.
In that footnote, yes, my lord.
And the other references is to Peterson versus Minister of Safety and Security in RF, which is a well-known appellate division case on delict. RF versus Minister van Politie, 1977, 2 SA 900.
Thank you, my lord.
And there's a sub-reference to another decision of the old NPD, as it was, in May versus Union Government.
Thank you, my lord.
Yes, we can go back there if you want to,
Okay.
to paragraph 27.
Thank you, my lord. In Tandanani, the court said that sight must not be lost of the fact that the liberty of the individual is one of the fundamental rights of a person in a free society, which should be jealously guarded at all times. And there is duty on our courts to preserve this right against infringement. Unlawful arrest and detention constitute a serious inroad into the freedom and the rights of an individual. My lord, the state didn't call this police who took my client from the hiking spot to come and testify. From there, he was taken to Jacobs Bay Beach, where he was further tortured. I will argue, my lord, that additional to Section 10, a right to be treated with human dignity, his rights in Section 12, 1A, and in Section 12, 1D, and in section 12, 1E were also violated.